Good afternoon, sir. Can you see and hear me?
Yes, I can. Thank you.
Thank you, sir. I'll carry on. Mr. Lusher, we were just discussing the local suspense account, and you referred to dispute resolution. I want to turn there now.
Mr. Stevens, on reflection, I may be able to give a slightly better answer to one of the questions which you asked this morning. Would that be helpful to the inquiry?
Yes, which question was that?
The question was about the global user availability password
Yes.
for auditors for the Horizon system. And I wasn't quick enough at the time, but on reflection, I just realised that if there was an unfortunate circumstance of the death of a sub-postmaster, then the auditors would be able to gain permission to use the system in order to wrap up the accounts, do whatever was necessary. I don't know the protocols for that, but it would certainly be something which wasn't dished out easily.
I see. So the capability was there to have these global user rights as far as you're aware. The circumstance you refer to is the death of a sub-postmaster, but you can't assist us with the control mechanisms in place for how an auditor would get access to those privileged access rights.
That's quite right, sir, yes. I hope that's helpful.
Thank you, and repeating it to make sure I had understood. Thank you. Local suspense account then, and if we could please bring up your witness statement, page 31, paragraph 111. Thank you. You start the paragraph by saying that you've been asked to explain what role the local suspense account played before its removal, and that was the removal in the impact programme. And you said the role of the local suspense account was to account for any unclaimed payments or receipts uncharged to the account. The suspense facility would also enable shortages or surpluses to be declared but not made good or withdrawn. For example, if the balance of account showed a shortage, this could be entered as an unclaimed payment, which would have the same effect as adding it to the cash on hand, negating the shortage. With permission, the facility could be used legitimately to hold discrepancies for up to 8 weeks, usually whilst awaiting an error notice. The facility was replaced by the debt resolution process. Now, the debt resolution process, I think we'll come to in a moment, but just to be clear, are you talking about the process that existed when transaction corrections came in and there was the option to settle centrally?
Paragraph 111 refers to the process before.
Yes.
Before that, and then unclaimed payments and uncharged receipts before, and then the settled centrally process after.
After. So we're singing from the same hymn sheet there.
Good.
You say, as I said, the facility could be used legitimately to hold discrepancies. Why did you use the word legitimately there?
It wasn't uncommon to find the system used without the permission which was necessary.
And in what circumstances would it be used without permission?
We're talking before the impact.
Yes, before impact.
So unclaimed payments, uncharged receipts weren't. I don't know the extent to which they were monitored, but the sub-postmaster would have the ability to use those whether he had permission or not. And so that would be one of the things that the audit team would be looking out for, unauthorised use of almost certainly the unclaimed payments table, being shortages rather than surpluses in the uncharged receipts.
Let's come to the permission aspect, excuse me, and we'll turn to a document POL 30888867. Thank you. At the top of this document, we see its liability for losses policy. Version control says 1.7 September 2003, but if we look over the page, it appears that it was a later version to July 2004. So this would have been in place when you were a contract advisor starting in 2005. Could we turn to page 5, please? The first two sentences, the sub-postmaster's contract requires that losses are made good without delay. Immediate settlement is therefore the expected contractual norm. Do you accept that isn't strictly in accordance with what the contract says? The contract says, as we covered this morning, it refers to the sub-postmaster's careless negligence or errors.
Yes, I do accept that.
And again, this document would be used presumably by contract advisors when considering how to deal with losses.
Yes.
Paragraph 2, excuse me, concerns a suspense account. And it says, under circumstances where the exact cause of the loss is known and a compensating error is expected to be returned, losses may be held in the suspense account with authority, providing that the agent has completed their own investigation and is able to show that an error notice is likely to be issued for that loss or an element of the loss. The agent, i.e., the agent must be able to detail a specific error that occurred for a specific client on a specific date and to be able to provide documentary evidence from the Horizon transaction log. So, in order for permission to be given under this policy, would you accept that the sub-postmaster has to be able to prove with a significant amount of precision that there has been a known error in the accounts?
Yes.
And so earlier in your evidence, when you referred to the suspense account being used for dispute resolution, it's not the case that the SPM could simply say, hang on a minute, I dispute these figures. I want to use the suspense account while this is being investigated. In order to get permission to use it, the sub-postmaster has to have done a significant amount of investigative work already.
There's a dichotomy there which I can't resolve.
And what is a dichotomy?
On the one hand, we're seeing here that the error must be specified, and on the other, I believe that the dispute resolution process allowed for a investigation. An investigation is not necessary if a loss can be proved. That's the dichotomy. Is that helpful, sir?
In terms of, excuse me, who would give the permission? That wouldn't be you, would it? Give permission to use the suspense account as a contract advisor?
No.
As we see in the next paragraph, it refers to the NBSC, and the last sentence in that again, it says, if there is no clearly defined evidence of a known error, and therefore no error notice likely to be issued, authority will not be given.
That's very clear, isn't it?
If we go to paragraphs, just further down this page, it goes on to say, to give authority to hold losses within the suspense account, even with evidence of the error, is against the principle of right first time. Granting authority to hold amounts in suspense should, therefore, always be considered to be the exception rather than the norm. Agents are expected to address the underlying cause of misbalancing and must expect that any subsequent errors of a similar nature will be referred to the retail line for corrective action. Does that fairly summarise how the suspense account was seen by members of Post Office? Or its use, I should say, the use of the suspense account.
Yes, I mean, clearly right first time refers to making no errors, that there should be no errors at all. And if there are subsequent errors, then a report for corrective action would be in line.
Please can we turn to page 8 of the same document? Thank you. Refers to horizon issues. As if an agent feels that an error has occurred via the horizon system, it is essential that this be reported to the horizon system help desk. Pausing there, that's the help desk that was run by Fujitsu at the time. Do you agree?
I don't know.
The HSH will only consider the incident for further investigation if the branch has evidence of a system fault. If no evidence is available, the case will not be investigated and the agent will be held responsible for making good the loss. System faults are very rare and are normally identified after a full investigation has been undertaken. All known system errors are managed through network support problem management, and access to problem management is via the MBSC. If the agent feels that the issue is not being resolved, they should flag the issue up with MBSC. If a known system error has caused a shortage, the agent should be given authority to hold the loss in suspense until the system error has been reconciled and the error notice issued. The point that system faults are rare and very rare and normally identified after a full investigation, or at least that they're very rare, that's consistent with your evidence earlier that as a contract advisor, you and others didn't think it was possible that discrepancies would be caused by horizon. Is that fair?
Yes, that's correct.
And did you have any involvement at all or in how Fujitsu, sorry, I'll rephrase that. Were you aware of how Fujitsu, through the help desk, investigated potential discrepancies in branch accounts?
No, sir.
So if there was a bug, error or defect in the horizon system which wasn't a known error, not known to the MBSC, do you accept that the sub-postmaster is effectively reliant on either the horizon system help desk or the MBSC identifying that error, and they can't identify it themselves?
Yes, that's what it says down here, yes.
And if they can't identify it themselves, the sub-postmaster can't prove that there's a known error or an error and has to make good the loss themselves.
That's correct too. I wasn't very involved in this process, but just drawing the logic from what you've read out there in section 6.
You weren't involved in the process, but at the time, did you consider that situation to be fair?
My involvement was to report any issues with the horizon system. We looked at the case of Rivenhall, where that's exactly what I did to report the problem there to Andy Wynne, and Andy in NBSC would have had access to the horizon system help desk and so on to report onwards. So my involvement was very limited. As to whether I think the system was fair, harsh, but in the light of information received subsequently, like in the last few years as a result of the inquiry, clearly it's not as fair as I thought it was at the time.
So we've discussed the help desk and how, in some ways, contract. If you're relying on the help desk to find an error, or the sub-postmaster is as well, that's one element. You've also referred to Andrew Wynne, Mr. Wynne. In your statement, sorry, that document can come down now, thank you. in your statement, at paragraph 21, which is at page 7, you say, when there were unexplained accounting shortages, team members would often liaise with the accounting department at Chesterfield or other departments to establish whether error notices were due to be issued. The system of rectifying errors could be slow and several weeks may elapse before a discrepancy could be corrected in the account. On occasion, there were a number of errors in the system. It became complex and sometimes almost impossible to pinpoint the cause of a discrepancy. Was it of concern to you that the post office back office staff would sometimes struggle to pinpoint the cause of a discrepancy, and yet the post office expected sub-postmasters to identify and evidence the cause themselves?
I don't think the post office staff had difficulty in identifying individual errors. The difficulty which I refer to here is when there are a number of errors in a sub-office account, it can become quite a complex matter to unravel the situation. It may take time to do that.
We then come to the involvement of Mr. Wynne, as you say, in paragraph 22. Either the audit or the contract team could refer disputed errors to the accounting team based at Chesterfield, who had access to the Horizon system and were very helpful in resolving errors, and latterly had a champion for difficult cases, Andy Wynne. When you say Andy Wynne was a champion, what do you mean by champion?
If there was a difficult accounting matter to be dealt with, Andy Wynne was the expert and had access to all the systems available to resolve any inquiries.
And so if there was a unexplained discrepancy and a sub-postmaster was suggesting that it was related to Horizon or caused by Horizon, would Andy Wynne be the go-to man?
Yes.
And did you see him as a safeguard to ensure that discrepancies in difficult cases were fully investigated?
I saw him as the expert.
Sorry?
As the expert.
The expert. Did you hear the evidence of Andy Wynne to this inquiry on the 3rd of March?
No.
When it came to discussing his time in the PMBA, where he looked at these accounting problems in branches, he agreed that his level of understanding of the role was basic and equivalent to an occasional end user. That's for the record transcript, page 26, line 8. He further accepted that his role required a much more detailed understanding of Horizon than he had, and his evidence was that he found technology quite difficult even now. Did you know that, you referred to him as an expert, did you understand him to have more than a basic grasp of Horizon?
Yes, sir, I did.
Did you continue to think that when you made your witness statement?
Yes.
And what was the basis of that belief that Mr. Wynne was a champion for difficult cases?
I don't know.
Do you have any?
I don't wish to guess, but I think he was put forward at least as the contact within P&BA to deal with these matters.
Now, with hindsight, having heard what Mr. Wynne said about his own experience, as I say, described as basic and equivalent to an occasional end user, do you have concerns or do you see there being a problem with the way in which Mr. Wynne was used by contract advisors to deal with discrepancies, unexplained discrepancies, I should say?
The fault may be entirely mine, but I'm somewhat shocked to find that Andy Wynne didn't have the expertise that I considered he had. And I don't know how other contract advisors regarded Andy, but it is a matter of concern to me now
And why is it a matter of concern to you?
because I relied on his responses and the information he provided. I myself am not an expert in the Horizon system. I can find my way around accounts quite well, but the system itself is not an area where I have expertise. And therefore, I relied somewhat on Mr. Wynne to provide that gap in my own expertise.
So when we looked at the Rivenhall branch earlier, and I asked about remote access, and you referred to Mr. Wynne, and you didn't pursue it further because of the information you were given. If at that stage you were aware of what Mr. Wynne now says of his level of expertise, would you have done anything differently?
Possibly.
Or what do you think you would have done differently?
I would have looked for somebody who had expertise in the system to give a definitive answer. I thought that person was Mr. Wynne.
Were you aware of anybody else at Post Office who may have had such expertise?
I would have hoped and expected that the gateway to that person would have been Mr. Wynne himself, had he not got the expertise personally, yeah.
Thank you. We then come to the impact programme, and this is where we deal with the introduction of transaction corrections. And the inquiry has had a significant amount of evidence on how that policy was developed and the settle centrally for amounts over £150. As I understand it, you were not involved in how that policy was devised.
Not as far as I can recall, no.
I'm not going to cover with you the settle centrally issue, which has been dealt with by other witnesses. What I do want to ask is about transaction corrections for under £150. So if there was a transaction correction for less than £150, the sub-postmaster would simply have to accept it, and they didn't have the option of settling centrally.
Yes, I believe that's the case.
And so a person could receive several of these throughout a year, which, even though under £150, could develop into quite a substantial sum of money.
Yeah, I believe that's the case, yes.
What, if any, what was the procedure for dispute resolution for those amounts?
I'm not aware of a dispute resolution process. The sub-postmaster would always have the help desk, MBSC, could make inquiries, but I don't believe, as far as I'm aware, there was a formal process for errors under £150 or transaction corrections under that amount.
Can I turn into page 33 of your witness statement, paragraph 118, just one further point on this topic. We were here right in the morning to look at paragraph 119, but it's 118 now I want to look at, and it says, there was not anything to distinguish a disputed debt from an undisputed debt, and I cannot see that the policy or the contract made any distinction. I understand you there to be referring to when a sub-postmaster sought to dispute a discrepancy or a transaction correction, and they settled centrally. The process is, or was said to be, that the enforcement procedures for recovering that debt would be paused while the dispute was resolved.
If the dispute process was invoked, yes.
So in that context, could you please explain what you mean at paragraph 118, that there was nothing to distinguish a disputed debt from an undisputed debt?
I may just read the one or two points beforehand
Yes, of
to understand the context of this.
Of course. Please could we just, I think it would help to start at probably at the bottom of the page before there, I think from there. And do just say when you're ready to
Thank you.
read on.
Thank you very much. And can I inquire of the question which was put to me to answer the point 118?
Sorry, I misheard you. That
I was responding to a question
yes.
to give the answer at point 118, and I'm not sure what that
Oh, I'm sorry.
question
Well,
was.
if we bring 118 back, so apologies, I misheard. Could you please explain what you mean here when you say there was not anything to distinguish a disputed debt from an undisputed debt?
I'm struggling to recognise the situation that I had in mind when I wrote that, but in terms of a settled centrally debt, then it could only it was a figure, and what it referred to, whether it was disputed or undisputed, there was nothing to distinguish between the two.
That document can come down, thank you. Was there a risk of Post Office seeking to enforce debt that was disputed if there was no distinction?
Under £150, definitely. And there would be inquiries ongoing to establish the reason for a debt before enforcement.
During your time as a contract advisor, were you aware of any sub-postmaster complaints about the transaction correction process?
Can't recall any.
Were you aware of the nature or volume of transaction corrections?
Some awareness, yes.
And what was that awareness?
The transaction correction rates for some products was higher than others. I know lottery, for example, attracted a lot of transaction corrections.
Were you ever concerned by the numbers?
In certain branches, it was certainly a matter of concern.
So when you say in some branches, you mean concern for the way that branch was running rather than general concern across the network as to how many transaction corrections were being generated?
Yes, that's what I meant initially, but there was concern in the network about the number of transaction corrections concerned with lottery. Probably the reason I remembered that one specifically. The accounting process was slightly more complex for lottery transactions.
And was there any concern or discussion that you're aware of that the volume of transaction corrections was caused by the Horizon IT system?
No.
I want to move on to look at suspension. And when I say suspension, it's often referred to as precautionary suspension of a sub-postmaster. Can you explain what the effect of a suspension on a sub-postmaster was?
Yes, when there was a suspension, then the trade at the branch would stop, as would the remuneration to the sub-postmaster. And normally there would be a search for a temporary sub-postmaster to take over. If that was possible, then it could be effected very quickly so that the customer base wouldn't be affected. But sometimes it did result in the closure of a branch for a period of time while investigations proceeded.
And what effect did it have on a sub-postmaster's access to premises, documents or data?
The sub-postmaster didn't have access to premises or data.
So the effect was significant.
Yes.
We don't need to turn it up, but at paragraph 145 of your statement, you say that there was no right to appeal against a decision to suspend.
That's correct.
So would you accept that the decision on whether or not to suspend a sub-postmaster ought to have been taken carefully and in accordance with the contract?
Yes.
We'll first look at who made the decision. Again, we don't need to turn it up, but at paragraph 135 of your statement, you say that for a long time, the contract advisor would consult with a senior manager before any decision was made as to suspension. As awareness of horizon difficulties increased, any such decision was taken at senior manager level. Let's start with awareness of horizon difficulties increased. Firstly, when did that occur?
I don't know the dates, sir, but I've referred to a continuum earlier in the day, I believe, when initially we came across the odd one or two cases, and it became public knowledge then as the inquiry started. And somewhere along that line, there was a stage where the contract advisors were less involved and senior managers took control of the whole decision-making process in regard of suspension and termination of contracts.
Let's look at a document which may assist. It's POL 000840002. This sets out for auditors the contact points for branch suspensions. We see in the first paragraph it's the 25th of September 2006. If we look, if we can go down, please. Thank you. So we see in the first column, we have people identified and their contacts in the next columns, and you're identified as first contact for Steve Gibbs, and then as a buddy contract advisor for Peter Pycock. So at this point, would the decision here, it appears that that's the contact point as a contract advisor. So in 2006, is the decision with the contract advisor with consultation of senior managers rather than it being the senior manager's decision?
I believe that was the case, sir, yes.
And then, thank you, that document could come down. And then there's a continuum you refer to. Do you think, can you recall a specific point? For example, in 2009, there was a Computer Weekly article. Did you read that at the time? Which,
not aware of that, sir.
I suppose, can you help us place when you think that horizon difficulties increased such that senior managers were involved and making the decision rather than yourself?
I can share a little confusion rather than help you, but it may help if I do that. In that, on occasions when my line manager in the period of interest was Lynn Norbury, on occasions when she was on leave, I would stand in for her and deal with inquiries from contract advisors concerning suspensions. I remember being surprised when a particular contract advisor phoned in to question her or to bounce the ideas around about a suspension, and I asked for the opinion of that contract advisor, and the response was, well, that's the decision at your grade, not at my grade. So it was quite clear that contract advisor considered that the decision was at senior manager level,
So when do you think that conversation would have happened? Was that in 2006 or later in the...
Later, 2008, 9, something of that order. But I was surprised by that, so it was clear that there was some confusion.
Why do you link a shift to senior management making this decision to awareness of horizon difficulties?
It was at the time when there was a reduction in the number of criminal prosecutions, and the business in areas above my pay grade were concerned about the horizon situation, and therefore decided to narrow the field of decision making in any matters relating to horizon.
So do you think that would have been around the time of the second site investigation, 2012 through to 15, that period?
Yeah, could well be, yeah.
And just to confirm I heard correctly, that was a decision from senior management to effectively...
Yes.
What did you think of that decision? Did you think you were, or contract managers were not capable of making a decision on suspension?
Yes, there was an element of that, especially contract advisors, some of whom had been in post for some considerable time, seemed a little bit undermined. But at the same time, it was what the business decided, so the decisions went to a higher grade.
When was the decision to suspend usually taken?
Normally it would be taken following an audit or during the process of an audit.
On the same day?
Yes.
We don't need to turn it up, but in paragraph 138 of page 39 of your statement, you say that you don't believe there was any process for the sub-postmaster to make representations about the decision, but it would often be the case that the contract advisor would speak to the sub-postmaster at the time of the audit. Is that based on your practice, or
Yes.
are you aware that other... Sorry, was that a yes?
Yeah, that was what I would do, yes. I
Yes.
always tried to speak to the sub-postmaster to establish the situation.
Was there variance in that practice across with other contract advisors?
Well, there may have been, I can't speak for them all, but it would seem sensible procedure to me.
At page 8 of your witness statement, paragraphs 24 and 25, paragraph 25 in particular, you say towards the end, suspension wasn't an exercise in assigning blame. It was done simply to control the risk and gather information until such time as the issues could be explained and rectified. What do you mean by suspension wasn't an exercise in assigning blame?
Perhaps we should regard suspension as stopping the risk to funds. It wasn't unknown for a suspension to last for a very short period of time. Investigations could be made, and within a day or two, the contract could be reinstated. And so the suspension itself was, as you referred to earlier, it was a precautionary suspension pending investigation.
And when you say that it's to reduce risk, is that what, of a risk of a sub-postmaster absconding with more money?
Yes.
Are there any other risks?
Yes. We referred colloquially to office accounts sometimes being in a muddle and sometimes as a result of a fiddle. In other words, an office account can quickly get into a situation where nobody's quite sure whether further errors are coming or whatever. And it needed a little bit of time, a breathing space to to resolve the error notice coming through. And it may be that what appeared to be a significant audit shortage could disappear because errors had been identified. And so that was the one purpose of a precautionary suspension. And if things did resolve themselves so that there's no discrepancy left, then a decision would be made on whether the sub-postmaster was sufficiently competent to continue in office, or whether the risk to funds would be too great, or whether this was perhaps with a new sub-postmaster, a case where additional training and support would resolve the situation.
So the question I asked was about risk, and one of them was about absconding with money. The other, you refer to the accounts themselves, and
one was about a fiddle, as I referred to.
A fiddle, yes.
Which obviously, I mean, nefarious activity within the accounts, perhaps theft or whatever. And the other was the muddle, which is where investigations, that's a risk. A muddle is still a risk because there may be a loss of control of the accounts and displaying incompetence of the sub-postmaster.
But at the time of the suspension, the audit's being carried out, so there's an independent record of what's in the post office, and the data is, for all your concern, the data's on horizon. So what is the additional risk that you're trying to identify that requires a suspension of a sub-postmaster in relation to a fiddle or muddle of the accounts?
The risk is that there may be errors in the system which are not apparent at the time of the audit.
Can we look at the contract, please? The relevant contract, it's POL 000-82751, page 90, please. This is I should say, the sub-postmaster's contract, as you'll see from the screen.
Thank you.
Thank you. If we could go to the bottom of the page, please. It says that a sub-postmaster may be suspended from office at any time if that course is considered desirable in the interests of Post Office Counters Limited, in consequence of his A, being arrested, B, having civil or criminal proceedings brought or made against him, C, where irregularities or misconduct at the office where he holds appointments has been established to the satisfaction of Post Office Limited, or are admitted or are suspected and are being investigated. So, as we see here, it says a sub-postmaster may be suspended. So, do you accept that the clause said that the post office had an option to suspend if suspension was considered desirable for one of the reasons stated?
Yes.
It didn't have to do so.
I accept that, yes.
So, this clause envisages that where there is a discrepancy, for example, raised, someone at post office will consider all the facts and consider whether it is desirable to suspend the sub-postmaster.
Yes.
And that person should consider all the relevant factors and dismiss or not consider any irrelevant ones.
Logic would dictate so, yes.
And they should make that decision in good faith.
Yes.
And in this case, Post Office entrusted that decision, well, it's unclear, either to contract managers or at some point a mixture of contract managers and senior management.
Yes, that's right.
Please could we bring up POL 0009004. Thank you. Not necessarily easy to tell from this, but it's understood that this is a pocket-sized booklet. You're nodding. Do you recall being given this?
Yes.
And at page 2, it's titled Managing Agents, Contracts, Guidelines for the Line Manager. Line manager, we've been using the term contract advisor. Would this be used by contract advisors?
The booklet was designed for contract managers or contract advisors or whatever they were called at the time, yes.
And its design is to be a reference book for contract advisors to use in how to apply post office policy.
Yes.
And did you use it?
Yes, it was available to me, yes.
It was available to you, but would you use it as a reference guide?
Yes, I would.
Can we turn to page 67, please? And towards the bottom of the page. This is a section on precautionary suspension. And it says that this course of action is considered appropriate in the interests of Post Office Network when A, the sub-postmaster is arrested, B, the sub-postmaster has civil or criminal proceedings brought against them. If we just go over the page, please. Or C, there are irregularities or misconduct at the post office or where grounds exist to suspect dishonesty. There are 2 additional points that we don't need to go into. If we can just go back up to have the original part of the text on the screen, please. This is different from the contract, isn't it? Because it's saying that suspension is appropriate when one of these factors is set out, not that it may be appropriate if considered desirable.
Yes, you've displayed the 2 different wordings there, yes.
And so did contract advisors see suspension as always appropriate when one of these conditions were met?
I would have given them the suspension consideration when, I mean, obviously if the sub-postmaster had been arrested, then yes, a suspension would be necessary. But if there were concerns, please, could we go to page 68? Would that be possible now, please?
So yes, of course. Just if we could go to the next page, please.
Yeah, where there are, I mean, it's about suspecting dishonesty, isn't it? But I would give suspension consideration rather than saying, yes, we will suspend.
And what would you take into account then? If you're making this decision, what would you take into account?
Experience of the sub-postmaster, size of the discrepancy, any admissions. Examples that spring to mind now.
Would you ever consider if there was evidence of actual theft, or just if it was a discrepancy enough?
Sizable. And evidence of theft can only be an admission, I think. I'm not sure what other evidence of theft could be provided.
Well, we'll come to that when we look at investigations in a bit more detail, or what evidence there could be. Let's have a look at another document. It's POL 000-86116, please. Now, in your witness statement, you describe this as an aid memoir. Do you recall when this document was made, or when you started using it?
No, I'm afraid I don't recall when the thing was made, but it was a useful document.
If you can't remember when it was made or a useful document, assume it was, let's just take a hypothetical date and it was made in 2008. If it was made in 2008, would it effectively set out what you would have done as a contract advisor before that date? So it wasn't setting new practice, it was just
it
setting
wasn't.
down
No,
what was
no.
done.
Not setting new practice. This was to bring together the wisdom of the time and the information in contracts and other guidance given.
And so this, when you say drew together the wisdom, this was effectively the thinking of senior management and contract advisors.
Yes.
If we could go down, please, to towards the bottom. Under the bold text, it says, if in any doubt, make decision to suspend and carry out further investigations. So presumably you adopted that approach as a contract advisor.
Yes, as I referred to earlier, reinstatement of the contract could be swift if investigations proved fruitful.
Yes, but during that time, when the decision to suspend is made, the sub-postmaster is without remuneration, yes?
Yes, yes.
And locked out of the premises.
Yes, yes.
So is another way of saying this that a contract advisor should suspend a sub-postmaster unless they are sure that the sub-postmaster did no wrong or that suspension was desirable?
That would logically follow.
Why was the burden of proof put on the sub-postmaster like that?
The issue would only arise when normally when a significant audit shortage had been identified. So that at that stage, then surely it would be fair for the sub-postmaster to provide some kind of explanation.
Well, earlier we referred to the fact that if a discrepancy had been caused by a bug, error or defect in the Horizon IT system, the sub-postmaster wouldn't be able to show that.
Yes, I agree with that.
And the contract said that the sub-postmaster was only responsible for losses caused by carelessness.
I agree with that too, sir.
So again, why did the fact that a discrepancy may have been over a certain amount mean that the sub-postmaster bore the burden of proof in persuading a contractor beyond doubt that they hadn't done anything wrong?
I hadn't done anything wrong. I mean, there's carelessness, negligence or error. The suspension just allowed time for that investigation to take place.
If you could go up, please, to look at some of these factors. The first refers to where there's been an admission or suspected misuse of funds, or an admission of inflation of cash or stock. If misuse is admitted, the amount is irrelevant. As a contract advisor, would you take into account if an explanation from the sub-postmaster, for example, if they said, well, I've inflated the cash or stock because I've got these unexplained discrepancies, for which I have no explanation. I think it's the Horizon IT system.
Yes, if there's no explanation and there's a shortage in the account, then suspension, I think, would be appropriate to enable investigation to take place.
So in those circumstances, just suspend. Okay. We've then got 2, if there's a discrepancy identified, and we're back to this figure of £1,000. A guiding figure for suspension is where a discrepancy is in excess of £1,000. Again, why was that seen to be a significant figure for suspensions?
I think I said before that I'm not sure why the figure of £1,000 was arrived at, but a smaller figure would, we need to recognise that suspension was an expensive process, as well as causing great difficulty to the sub-postmaster. So for smaller sums, then probably not appropriate.
Well, when you compare a company the size of the post office and what effect £1,000 discrepancy would have on it, compared to the effect of a sub-postmaster and the effect of no remuneration, do you think that £1,000 was too low rather than too high?
Certainly on the low side, but that's the figure that was produced for us, and that's the figure we worked to.
Why was the size of branch relevant?
Some of the branches of the post offices were major high street stores with very high level of turnover and so on. And some of them were very, very tiny sub offices in the countryside, possibly only open for a few hours a week. So that would certainly be taken into account.
And but in which way? So if it was a smaller sub-post office, what would that be more or less likely to result in a suspension?
Well, all the factors have to be taken into account, not just the size of the branch.
Well, is it the fact that the size of the branch was taken into account for the post office considering its own turnover, in the sense of a bigger branch being suspended would result in post office's turnover?
Yes, that would certainly be a consideration. There'd be more inconvenience to the public, and as you say, less turnover for the post office, and a larger branch. So one would want to avoid termination of a large branch, if possible.
And so a smaller branch would be more likely to be suspended on these guidelines?
Yes.
And what was the relevance of settling debt centrally, both the proportion and frequency?
So I referred to a model before, and if a sub-postmaster was incompetent, then it could result in frequent debt being settled centrally and frequent transaction corrections, as stated here. So it would be an indication that something was not quite right with the accounting at the branch.
And the final one, the sub-postmaster's ability or willingness to make good the loss. Well, firstly, why was the sub-postmaster's ability to make good the loss relevant to whether or not they would be suspended?
Again, if there was a question of incompetence, then the debt could increase over a period of time, and a suspension would prevent that increase in debt.
And a willingness, would someone who was more willing to make good the loss be less likely to be suspended?
Yes.
So does that mean someone who was disputing the loss be more likely to be suspended?
Yes.
There's no reference here to whether or not there was evidence of the sub-postmaster calling the MBSC or the Fujitsu help desk. Was that ever considered by contract advisors?
Just the frequency of calls to NBSC for help, you mean?
Or if they were calling for help with Horizon, saying, I've made regular, each week I'm getting problems and I'm calling the help desk. I'm not getting any assistance. Would that be taken into account?
Yes, I recall information being available which indicated the number of calls to the help desk. I think that information was generally used for risk analysis to decide which branches to audit. One of the elements there is
So that's used for audit, but in the sense, when you're considering whether or not to suspend someone, would you
so
consider
if that information was available, that's certainly something that would be taken into account, yes.
So why isn't it written in this list?
I can't answer that.
Number 3 considers absentee sub-postmasters, which we don't need to consider. And then we've got 4, gain opinion from auditor. Could you just flesh that out for us? What would
Yes.
be being sought?
Yes, I mean, in principle, the auditor was there to provide the numbers and purely the facts, but they were at the office, and they may have gained an impression that the sub-postmaster was, for example, trying to cover something up or being difficult in one way or another. So the auditor may think, oh, there's something really wrong here, or they may equally find that the sub-postmaster was floundering in a muddle and indicate that way. And that would just be a bit of helpful information in decision making.
Finally, consider potential future risk to Post Office limited funds if the sub-postmaster is left in post. What sort of points would you be considering there as distinct from what's gone before?
I think it refers to the level of competence of the sub-postmaster. So if the sub-postmaster is incompetent, then Post Office funds would be at risk if the office was allowed to continue.
Did you ever consider alternatives to suspension, such as more frequent visits or advice and input from the field,
yes.
the networks support agents?
Yes, definitely. Yes, and even after suspension, then reinstatement would, often then require additional training, additional support of one way or another.
Can you ever recall a time when you didn't suspend a sub-postmaster and instead put in place an alternative in place of suspension?
I can't recall a specific occasion, sir.
Can you recall an occasion when you were faced with a sub-postmaster who had a discrepancy in excess of £1,000 and you decided not to suspend them?
Well, again, I can't remember a specific case, but we are dealing with more than 10 years ago.
Thank you. So that's probably a good time to take the afternoon break, as I'll be going on to another topic.
Again, I was struggling to unmute myself, but I agree.
Thank you, sir. Would 20 past work?
Yeah, sure.
Thank you, sir.
Thank you.
Good afternoon, sir. Can you see and hear me?
Yes, I can. Thank you.
Thank you. Mr. Lusher, I'm now going to go on to discuss termination. We discussed the effect of suspensions before the break. The effect of termination is obvious. It brings the post office element of the sub-postmaster's business to an end. So again, presumably, you accept that that is a very significant decision to make.
Absolutely.
And the difference between the precautionary suspension and the termination is you have time to investigate.
That's right.
Who carried out that investigation?
If there was a potential for a criminal investigation to take place, then the main investigation was taken place. It took place by the investigation team themselves. And if not, then the the contract advisor would interview the sub-postmaster and establish, well, that was before termination, clearly, establish whether to terminate or reinstate with conditions.
Right at the beginning of your evidence, when we discussed when an auditor might involve the investigation department, you referred to the £1,000 figure as being indicative of whether it may be referred to the investigation department or not. And we went to the suspension guidelines, which use the same figure. In most cases you dealt with of suspension and termination, was the main investigative work done by you or someone in the investigation team?
The investigation team made their own decision as to whether they would be involved in the investigation with a view of criminal prosecution. And if they did, then they had the trump card. And so the contract advisor would, if there was a criminal prosecution to take place, then the contract advisor would terminate the contract. Clearly, the business wouldn't want to reinstate a contract when the business was going to then proceed to prosecution. But if the investigation department decided not to investigate looking for criminal prosecution, then the contract advisor would conduct the full investigation.
I want to look at one of the situations where there was an investigation, one of the case studies that that the inquiry will be looking at in much more detail in due course. Involves the prosecution of Suzanne Palmer, who is a co-participant and sits within this room. Can we go to the investigation report that was prepared? It's POL 000-53007. For the time being, if you could zoom out, please, to see the full of the thank you. Do you recognise this type of document?
Yes, this is a report from the investigation department.
And when would you come across these in your practice as a contract advisor?
Would be presented probably prior to the termination of the contract and after suspension. Would
this be a significant document as part of that you would take into account as part of the decision as to whether or not to terminate the contract?
Yes, that's right.
We see designated prosecution authority towards the bottom, Tony Utting. Did you work often with Mr. Utting?
Mr. Utting was part of the investigation team. I wasn't. But I certainly recognise the name, and I believe Lisa Allen produced this report. And again, she was an investigator who produced this and a number of other reports which I saw.
You're referred to as the discipline manager.
Odd title.
Is that it? Sorry, I always spoke over you then.
I spoke over you, sir. But just to say that it's an odd title, discipline manager. We talked about employment law and contract law before.
Yes, we said exactly that, disciplinary procedures. The fact your title was discipline manager suggests that this was seen as a disciplinary procedure. Do you agree?
It was a contractual matter that I was dealing with. It was a criminal matter that the report was dealing with.
Can we go to page 6, please? We see this is a document by Lisa Allen, so she's the investigation manager, on the 20th of February 2006. To what extent, if at all, would you have had any input into Lisa Allen's investigation?
I believe on this occasion the auditors found a discrepancy, a deficiency in the office accounts, and it just happened that on the day Lisa Allen, the investigator, was available, and so I believe she went to the office on the day and completed the report. I can't be certain it was on the day, but I think it was, or possibly the next day.
But in preparing this report, and you made the decision to suspend on the 3rd of February, and subsequently made the decision to terminate. As part of this process of determining whether or not you would terminate Mrs. Palmer's contract, how often, if at all, did you speak to Ms. Lisa Allen?
The information that I would need from the report was whether there was going to be a criminal prosecution. I don't recall speaking to Lisa Allen in 2006. I may or may not have spoken to Lisa about the report.
So if what you said there was the information that I would need from the report was whether there was going to be a criminal prosecution.
Yes.
So if there was going to be a criminal prosecution, would you effectively see that as it has to be a termination?
Yes.
Why?
Would be for Post Office Limited to be pursuing a criminal prosecution and then reinstating a contract would seem to be incongruent, silly.
Did you ever question decisions as to whether or not to prosecute?
They were made at a very high level, and I wouldn't have questioned them, no. It wouldn't be Lisa's decision.
It says, the third paragraph up, a discipline report has been forwarded to Alan Lusher. What was a discipline report?
I believe that refers to this report.
That document can come down. The inquiry has seen evidence of very significant discrepancies being reported and investigated, upwards of £100,000. As part of your investigation, did you ever investigate whether there had been an actual loss, such as by trying to trace where allegedly lost money had gone?
So we're not talking about Suzanne Palmer.
No, I'm sorry, I'm talking
we're
generally.
nothing like so large. So you're asking if investigations were made when very large sums went missing?
No, well, let's not limit it to large sums. As part of your investigation, did you ever try to trace where allegedly lost money had gone? So there was a discrepancy on horizon, but did you try to see if, for example, you could trace where the money had gone, maybe into the sub-postmaster's bank account or into a safe at home?
Limited attempts. The investigation team would go into much more detail.
And when you say limited attempts by yourself, what would those limited attempts be?
It would be asking the sub-postmaster where the sums of money had gone. There wouldn't be any detailed investigation beyond that, I don't believe.
And what if they said, well, I don't know because I haven't stolen them?
I wouldn't be in the business of accusing anybody of stealing money. I would be in the business of finding that there was a deficiency in the account which could possibly warrant suspension and or termination.
As part of your investigation, would you ever request audit data or ARQ data from Fujitsu?
You referred to ARQ data this morning. I can't quite remember what it was because I'd never heard of it before. But no is the answer to the question. I would never refer to Fujitsu for information.
Why not?
I didn't have the avenue through which to do that.
Do you think it would have helped you to be able to see, if you're trying to determine the cause of a discrepancy, to be able to see the data, the more detailed audit data collected by Horizon?
Yeah, potentially could, yes.
In relation to who made the decision to terminate, you say a similar thing, that initially a contract advisor with input from the senior manager, and then over time that position changed. Are the timings the same as with suspension?
The contract advisors had a monthly appraisal meeting with the senior managers, and on each occasion, any cases such as these suspensions, terminations would be discussed. And so the opinion and guidance of the senior manager would always be in the decision-making process.
But in terms of when that the actual decision-making went to the senior managers rather than in consultation with, did that transfer about the same time as for suspension?
Probably yes, possibly earlier.
We've discussed that sub-postmasters aren't employees, but often in an employment context where there's an allegation of misconduct of some sort, you may expect to see an investigating officer and a separate decision maker. Would you agree with that?
I don't know. I haven't dealt with such things.
Could we please turn in your witness statement to page 39, paragraph 141. Thank you. You say at interview, evidence would be heard from the SPM and the contract advisor. Who would hear the evidence?
The contract advisor would put forward evidence that they had, the sub-postmaster would put forward evidence that they had, and the contract advisor, often with the assistance of the friend, the member of the Federation of Sub-Postmasters, normally very helpful. Then the contract advisor would arrive at a decision jointly or with senior management subsequently.
So the contract manager does the investigation, or it may be the investigation department. There's then the meeting. The contract manager puts forward all the evidence, and then the contract advisor again, or manager, makes the decision. There's no separation between investigation and decision making.
That's right.
Do you see a problem with that?
The senior managers were always involved in that decision-making process.
And how does that address the problem with the investigator making a decision on their own investigation?
I didn't say I found that to be a problem, did I?
You don't consider it to be a problem? Is that your evidence?
No, I don't see that as a problem.
So, during a interview, were there ever occasions when a sub-postmaster may criticise the extent of the investigation and say more evidence is needed?
It may have been the case, I can't recall.
If such a criticism was made, would you feel that you, as a contract advisor who's done the investigation, would you feel that you'd be able to impartially assess that, whether the investigation itself was adequate?
If there was something specific that the sub-postmaster wished to raise, then that could be a new avenue of investigation. which the contract advisor could then explore.
How often in your experience did a sub-postmaster raise a new area of investigation and that was then following an interview?
Can't recall any specific occasion, sir.
I want to briefly look at appeals and at paragraph 146 and 147 of your statement, please. It's page 40. You say that the SPMs did, however, have the right to appeal a decision to terminate their contract. Appeals were heard only by specially trained senior managers. And you go on to say you recall taking notes, but you didn't actually conduct an appeal yourself.
Appeals had to be heard by senior managers, and they never achieved that status, sir.
In paragraph 150, you refer to being consulted on revisions to appeals policies and to arranging training.
Yes.
Why were you consulted on appeals policy if you weren't running appeals yourself?
I think for a time, this was when I was termed, I believe, a commercial contract advisor and not doing the ordinary role of a contract advisor. But at the time, the appeals were almost all heard by just one appeals manager, Andy Bayfield. And the decision was taken that a panel should be established, as had previously been the case, I believe, some years prior. Is the connection satisfactory, sir?
I think so. Yes. So can you see and hear us?
Yes, yes.
I think it may have just been
The screen went off, sir.
Yeah.
I'm sorry.
Currently on my screen, I've got, just so everybody knows, I've got the witness statement at paragraph 50.
Yes, that can come down. Sorry, that can come down. Thank you, sir.
Sorry, the question was, why did I become involved in a revision of appeals process when I wasn't involved in appeals?
Yes.
And the answer is that at the time when I was a commercial contracts advisor, just one person, Andy Bayfield, was concerned with conducting all appeals throughout the country, and the decision was taken to form a panel of appeals manager with specific training in order to alleviate the workload. And I was asked really, I think the policy was just a question of pulling together whatever had been there before into a consolidated piece of work, and then assisting with the training of the new appeals managers. I think my experience as an auditor was quite useful in that, just to help to train the appeals managers.
Are you aware of how frequently appeals would be allowed?
Yes, I think there was, in the pack, there were some statistics which indicated in the order of 35, 40 appeals a year, if my memory serves me, but that was from the pack which was provided to me.
Well, if it's from the pack, we can consult the documents in due course, but from your own memory, you don't have a recollection of how many appeals were, as in allowed, as in initial decisions overturned.
Oh, I see what you mean. Decisions overturned, I don't really recall that number. There were some, but not very many.
And in practice, was allowing an appeal frowned upon within the post office?
Oh, no.
Why do you say that?
From a contract advisor perspective, an appeal would be welcome because that would give somebody else the opportunity to review the entire case. The appeal was not based on the contract advisor's investigations or findings, but there was a completely fresh rehash of the case from stage one, always conducted by a senior manager.
I've got three disparate topics now. One of them is back to the prosecution of Mrs. Palmer. There's going to be more questions coming, but I'm only going to focus on one particular element. And firstly, could you just briefly say overall what your role was in that prosecution?
I had no role in the prosecution, sir.
If we can turn, please, to POL 30529988. This is a letter dated the 8th of November 2006. It is from Miss J. Andrews in the Criminal Law Division and addressed to, we see, investigation team, but CC Lisa Allen. It refers to Post Office against Palmer with a pre-trial review on the 8th of December. If you could just move down slightly, please. Thank you. The third paragraph says the witnesses required to give evidence at trial are Peter Richards, Alan Lusher, Anil Chowdhury and Nick Kerr. Do you recall giving evidence in this trial?
No.
Did you
I did not give evidence at the trial.
Did you give a witness statement?
I may well have done. I cannot recall.
I think the reality is that you must have done, because a witness order or a request that someone gives evidence must be preceded by a witness statement in a criminal case.
Thank you, sir. In that case, I must have done.
That document can come down. Can we please then go to POL 000-52997? The letter dated the 19th of January 2007, again to the investigation team, CC Lisa Allen, but at the bottom we see that it's from Jarnail Singh. Did you work with Jarnail Singh at all, or do you know who he was?
I may have been aware of him at the time, sir, and it's clear that he's on the Criminal Law Division, so not really closely related to the contract issues.
The letter refers to receiving a letter from defence solicitors with regard to disclosure of any post office accounting records that show Mrs. Palmer did periodically repay the post office large sums of money representing scratch card receipts. They informed me that prosecution counsel gave an indication on the 8th of December 2006 at court, and we asked the investigation officer, and his understanding was that such records did exist. However, no such records have been disclosed. Could you please look into this and let me have your response urgently? Can you recall ever being approached to provide documents in relation to this case, in particular accounting records?
No, I can't, and the request would have gone to the accounting department rather than to myself, I believe.
Thank you. Now, the second topic I had, if you bear with me, so I need to open the transcript. Apologies, technical errors, would you believe? Thank you, yes. This morning, I asked you questions about where assurance came in respect of Horizon's reliability. And we had a discussion and you referred to senior management, etc. reading from the transcript, the question I asked was, when you say you were advised by Post Office Limited, who in particular assured gave you that assurance? I'll then read your answer back to you. It said, well, the discussion came up in team meetings on a fairly regular basis. Not exactly sure of the dates, but the first inklings of activity in 2004, 2005, something like that, right through to the end there, was kind of a continuum. Of all things, the pressure got increased, as it were. Initially, there's not too much consideration given to it, and this is the part I want to ask you about, but latterly, the Post Office does, inaudible, a statement to read out with application interviews, which the legal team had prepared to assure people that the Horizon system was sound, and so, latterly given. And then it breaks off. Your reference there to a statement to read out with application interviews, which the legal team had prepared to assure people that the Horizon system was sound. Could you please just expand on what that was?
One of the key jobs of the contract advisor was application interviews for new sub-postmasters. And as part of the interview process, a document had been prepared by the legal team, either to read out, to refer to, or I believe to actually hand to the applicant at some stage during the interview process.
And do you recall what that document said?
Not specifically, but it was to give assurance that the Horizon system was sound.
And do you remember when that was, can you be precise as to when that document was brought in?
I can't be precise, but on the continuum we've referred to as 2012 or thereafter.
Can you remember who precisely instructed you to use that document?
Well, the instruction came through my line manager, but it was produced, I believe, by the Post Office solicitors.
Who was your line manager at that time?
Lynn Norbury.
It was Lynn Norbury. Thank you. The final question then I have, please, or set of questions, sorry, could we turn up POL 000-41476? And if we could go to the last page, please, page 4. So this is an email from you to Paul Inwood on the 14th of June 2017. We don't have the attachment, but it says, "Hi Paul, I would appreciate advice on the best way to proceed with this case." Why would you approach Paul Inwood in these circumstances?
The email is copied to Lynn Norbury, my immediate line manager, and Paul Inwood was, I believe, involved in putting together contracts, but also had a close interest in the Horizon issues. We note that this is much later in 2017, much later on my continuum.
Continuum, yes.
When there was general concern in the business about the inquiry and Horizon difficulties.
Could we go over the page, please, to Mr. Inwood's response? Thank you. So, just to see for the chronology purposes, he responds asking for more information. The actual content of the advice isn't necessary for the question I'm going to ask. What I want to ask is your email, which is immediately above. So this is from you back to Paul Inwood on the 31st of August. And you say you've made inquiries with Angela van den Bogert, having no recollection, etc. But your penultimate paragraph says, "Please advise whether I should proceed with this case differently in any way because of the implication of problems with the Horizon system." Now, were you requesting whether you should do something differently because of the ongoing litigation concerning Horizon at that point?
Yes.
why did you think it necessary to ask whether you should proceed with the case in a different manner?
You forgive me if I pronounce the name wrong, but Penturk is an office, I believe, in Wales. I live in Norfolk. The case was passed to me to deal with kind of specially because there was concerns around the Horizon system, I believe, which had been brought up by the sub-postmaster in this case. So in a way, I was just the lowly contract advisor dealing with the regular letters to be sent in this case, but took advice from very senior managers. Obviously, Paul Inwood carried the case forward to a senior legal expert in the business, and so I was just merely doing the donkey work to start the process on this case.
So in practice, around this time when the group litigation was, that document can come down, thank you. When the group litigation was ongoing, if you had a query as a contract advisor which raised a Horizon issue, it would be normal practice to raise that up to senior management for guidance on what to do.
To answer, sir, I wasn't working as a kind of ordinary contract advisor in that time from was about 2010 onwards, but on odd occasions was asked to deal with specific cases. And when Horizon was mentioned as an issue, then yes, certainly the matter would be referred to senior managers and lawyers.
Thank you. That concludes all the questions that I have. Sir, there are questions from two co-participants. Firstly, Mr. Enright for Howe & Co.
Over to you, Mr. Enright. And I can see that Mrs. Palmer is with you, so give her my regards.
I will do, sir. Thank you. Mr. Lusher, I'm David Enright, and I'm the recognised legal representative for 156 sub-postmasters and managers, including Ms. Palmer, who sits beside me. I saw you looking earlier. Do you remember Ms. Palmer?
I do indeed.
You were Ms. Palmer's contract manager.
I'm not certain whether I was.
You were Ms. Palmer's contract manager, correct?
I'm not certain whether I was her designated contract manager, but I definitely dealt with the case.
You definitely dealt with the case. Mrs. Palmer appeared before the inquiry on the 23rd of February 2022, and she referred to you in her evidence. Did you watch her evidence then or later?
No.
Did you watch the evidence of any of the postmasters who gave human impact evidence?
No, I haven't done so, sir.
Ms. Palmer also produced and provided a witness statement to this inquiry, and I'd like you to take you to 2 paragraphs of that statement. I'd be very grateful if we could bring up WIT NO 2240100. This is the witness statement of Ms. Palmer. If you'd be kind enough to take us to page 12. I'm looking at paragraph 55, Mr. Lusher. Mrs. Palmer said in her statement, I also attended an interview with Alan Lusher, contracts manager, in or around March 2005. I went through everything with Alan and explained my accounting process. He could see that I had done it incorrectly, but this was naivety of the system rather than malicious. Alan tried to stop the prosecution, but explained that the decision to prosecute was made by a separate team. So Ms. Palmer says that you understood her position and tried to help her. Do you remember this?
I certainly remember the interview, specifically because Ms. Palmer was extremely upset at the time at the prospect of losing the office.
So you met her because you remember her being deeply upset?
Yes.
Did you promise to help her in any way?
I would have promised to do anything that was within my power to assist her and ensure that justice was carried out fairly.
Do you recall saying to her that you understood, you could see that there was a muddle here, there was naivety here, there was not criminality here?
I wouldn't go that far, sir, no.
Okay. So you didn't do anything to try to stop her prosecution then, I take it?
The decision on whether to prosecute or not was not at all within my remit, sir.
All right. You'll of course recall, certainly haven't heard the evidence, that Miss Palmer was prosecuted by the post office and was tried on 3 counts of false accounting. You shake your head.
Yes, I've seen the evidence, yes.
Do you recall that a jury acquitted her on all counts in January 2007?
I have heard that that was the case, sir, yes.
Okay. I'd like to go to paragraph 14 of her witness statement. It's page 14 of that statement. I'm looking at paragraph 68. And this is what Mrs. Palmer says she did immediately after being found or acquitted. I called Alan Lusher the day the verdict was handed down and told him I was found not guilty. He was really pleased with this. However, I had been through months of hell, and even though I was proved innocent, the post office took away my job, my income, my business, and my future. So the questions I have for you are these. Were you happy that Mrs. Palmer was acquitted?
Yes, sir, I was.
Do you remember that phone call when she rang you to tell you?
Yes, I do recall.
Given that, did you escalate Ms. Palmer's position with Post Office after her acquittal to see what could be done about reinstating her after she had been acquitted of any wrongdoing?
Did I escalate?
Yes.
Yes, I referred the matter to my line manager. I believe when I first hesitated, when you asked me if I was Ms. Palmer's contract manager, it's because the branch is quite a long way from where I live and was most probably within the area of another contract advisor. But we worked, in teams. So if the other contract advisor's workload was heavy, I would take on a case. My line manager at the time, Lynn Norbury, I believe, referred the matter after we'd heard about the not guilty verdicts to the contract manager who looked after the area. That'd be Carol Ballon.
What was the name of that person?
Carol Ballon.
Thank you. And did you discuss this matter with Carol? You must have, obviously, because you raised it with her.
I raised it with Lynn Norbury, my line manager,
Right.
who is also the line manager of Carol Ballon.
Did you give a recommendation about what should be done after she had been acquitted of all charges?
The criminal case had been put forward, been challenged in court, clearly found not guilty, but the contract had already been terminated at that stage.
We're not entirely clear whether you were her contract manager or not. It does appear that you were. Wasn't it part of your job as a contract manager to intervene when the post office got it wrong? Shouldn't you advocate for someone who had been wrongly prosecuted and found not guilty?
The investigation team would be at least as responsible to admit that they got it wrong if that was the case.
Now, I appreciate what they may or may not have done, but I'm talking about you as her contract manager. A manager is not all about negative. A manager is also about positive.
Yeah, of course, yes. We're dealing with 2006, and I don't recall the specific conversations around this part. I mean, there are elements of the case. I was asked to deal with another case with Ms. Palmer, so I've been familiarised with the case over the recent years. But I don't recall specific detail from 2006.
I'll just ask you one further question on it, because you have said you remember the name of the person who you raised it with. So you do remember Ms. Palmer being acquitted. You do remember raising it with your line manager.
Yeah, yeah.
Did you advocate for Ms. Palmer? Did you suggest she should be reinstated?
I wouldn't have suggested that she be reinstated.
Well, Ms. Palmer was acquitted of all charges brought against her by the Post Office, and yet she lost her livelihood, her home, and her reputation. Is there anything you'd like to say to her today?
I'm very, very sorry that things have panned out how they have for Miss Palmer. I certainly remember her for being a particularly pleasant person, easy to deal with. And I also remember specifically thinking that the interview which we referred to, had that been an application interview, she would have been a very good candidate to be a sub-postmistress. And that's the truth, sir. I'm very sad for the way things have turned out for you.
Thank you very much, Mr. Lusher.
Who else wants to ask Mr. Lusher questions?
Ms. Page from for Hodgson Allen.
Yeah.
Thank you, sir. Mr. Lusher, I ask questions on behalf of another group of sub-postmasters, and there's just one document that I'd like to take you to. It is Poll 302 9677. And while it's coming up, Mr. Lusher, it is well, here it is. It's the Debtor Net Reveal review of fraud and non-conformance in the Post Office. This took place on the 1st of October 2013. Did you hear anything about that or know anything about that?
I've read this report, and though I can't be sure, I believe I was invited to give information to one of the researchers before the report was produced.
You didn't read it at the time, though, or did you?
Oh no, this wouldn't have been presented to my level. This would have been for board level, I guess.
What I'd like to do is just look at the bottom of page 33 and going into page 34. So just pausing there, this is the bottom of page 33, and this is about sub-post office branch behaviour in relation to what the report terms non-conformance. And we can see that there's a breakdown of various different types of sub-post offices and the percentage of them which fail audits. So we can see there that offices with no DVLA applications failed 23% of the time, which is relatively high. But if we go all the way down to the bottom where they have no additional services, no ATM, no Camelot, no DVLA, no automated payments, etc., there's just a 1% failure rate. Do you see that?
Yes, it would be helpful if we could decide what a failed audit means.
Well, it says here at the top, SPMR failure rates appear to be very much determined by which services they do not offer. Removing the ATM reduces the risk of SPMR being suspended, as does the presence of lottery tickets. So I think what it's referring to is when an audit leads to suspension.
Okay.
Does that make sense?
Yeah, it does, yeah.
We then go over the page, and it then talks about multiple sub-office behaviour. And what it says is multiple sub-office multiple sub-post offices are by far the weakest performers in terms of conformance. It says, once again, the absence of the ATM appears to reduce the risk. However, the failure rate is still considerably above the average, which is about 14%. And then it says that there's... Sorry.
May I just interrupt?
Certainly.
I'm sorry to interrupt, but the The title of this paragraph is multiple sub-post office behaviour, and multiple sub-postmasters to me means the branches operated by the co-op or one-stop.
Exactly.
But the cluster name is MSP03, and that's a modified sub-post office contract. And I wonder if we could just clarify whether we're referring to the post offices under the modified contract or multiple sub-post offices.
In the context of the report, it's pretty clear that they're talking about multiples.
Okay.
Which is really why I draw it to your attention, because that was one of the areas that you ended up doing a lot of work in, isn't it?
Yes, yes.
And we can see that because below there's also a reference to chain franchise behaviour. And so that's a different form again, isn't it, where you have chain franchises. Is that right?
Yes, that's something different.
So just to return back to the one, the paragraph dealing with multiples, we can see that there's a description of high stock discrepancy, unpaid check transactions. And that's I think, a type of failure. And we see that 50% of the multiples are failing in that regard. And then when we have multiples which do everything, 36% are failing. And then when we have no ATM, 21% are failing, all of which are higher than the failure rates that we saw with reference to single sub-postmasters. Were you aware that multiples were much more prone to non-conformance and failure of audits than single sub-postmasters?
No, I wasn't aware. Multiple sub-post offices, if there was an audit discrepancy, then with an independent sub-postmaster, we'd follow the procedure which we've discussed at length today of suspension and interviews and termination and so on. But with the multiple partners, then they themselves would deal internally with issues at branch. So they may choose to terminate the employment contract of their manager, for example, and replace them with somebody else, or come to whatever arrangement they chose. So that the issue wouldn't be so onerous on the contract advisor to deal with.
No. And it appears, doesn't it, from what Detica and Net Reveal have found, is that multiples were given really rather more latitude than single sub-postmasters in terms of non-conformance.
By the post office?
Yes.
Yes, I would say that's the case. But by the operators themselves, the multiple partners, then they dealt with the matters in their own way.
Well, yes, they did. And what it looks like is that they didn't deal with it in a way that produced the same levels of conformance that sub-postmasters produced.
From these figures, it would seem that what you say is correct.
And so what we perhaps might draw from this is a culture in the post office which took advantage of a power imbalance between the post office and the sub-postmaster in comparison to a more bilateral, less imbalanced relationship between the post office and chains like the co-op.
I accept that because of the figures in front of me, the effect of action taken by the multiple partners was less effective, can't be disputed because of the figures you present, or the figures that are presented in this report. But in terms of favouritism or a different approach from the post office, the mechanics of the approach were different, as I explained, but not a matter of favouritism, I wouldn't have said.
Can I just ask very briefly one more thing? That document can come down. This is just a question that arises from the document you've seen already on a different subject. The emails about the post office at Rivenhall and the exchange that you had with Mr. Wynne, who informed you that Fujitsu had the ability to impact on branch records via the message store. Were you aware that that email exchange became a point of focus during the second site investigation?
I haven't followed the investigation closely.
Did anyone talk to you about it during the second site investigation?
No.
Thank you. Those are my questions.
Thank you, Ms. Page. I do have a few questions to ask you,
Yes, sir.
if Mr. Lusher. And could we have Mr. Lusher's witness statement on the screen at paragraph 66, just so that we can look at the contractual provision again? Paragraph 66 is on page 19. And if you scroll out, there we are, that's fine. And you've very properly set out in paragraph 66 that your understanding is summed up by the contractual provision which you then cite, yeah?
Yes, sir.
And Mr. Stevens showed you a number of documents, or at least some documents, let's exaggerate it, which tended to suggest that the sub-postmaster was responsible for all losses, full stop, so to speak. And so there was a difference between the strict contractual provision and some of the documents produced by the post office, yeah?
Yes, that's quite true, sir.
Right. Now, what I want to ask you about is your knowledge of what happened in practice. Can I it that and we'll pick up the train, so to speak, when the auditor has reported to the contract advisor that there's a loss showing at a particular branch, all right?
Mm-hmm.
And so a decision has to be made by the contract advisor as to suspension or not. And I take it that the contract advisor would be asking himself the question, is the sub-postmaster responsible for this loss? And there might be two ways of looking at that. One, strictly in accordance with the contract, or two, perhaps in accordance with what some policy documents might describe as the responsibility for loss. So two questions. First of all, when you were a contract advisor, did you address that issue?
It's difficult to remember any specific examples, sir, but my intention would always be to be as fair and as just as possible with the sub-postmaster. It was rare in the circumstance that you refer to, an audit taking place. It was rare to come across a loss which wasn't caused by carelessness, negligence, or error, or by an assistant. The only examples I could usually remember would be in terms of robbery and burglary.
Yeah, I understand that, but what I'm trying to get at is, were you applying a test which in effect was the postmaster is responsible for all losses, or were you applying a test which was that he was responsible for losses if he was careless, negligent, or in error?
The second is definitely the case, sir. I would refer to the contract, carelessness, negligence, or error.
So you personally would always go on the contractual basis. Is that what you're telling me?
Yes, sir, it is.
Right. Now, the other question I want to ask you in relation to that is, in your mind, was it for the post office to prove that he was careless, negligent, or in error, or was it for the sub-postmaster to prove that he wasn't?
The post office would go some way to investigate the situation so that the contract advisor, myself, sir, would be confident, to some degree at least, that there was carelessness, negligence or error. And the case would then be referred to the sub-postmaster for him to prove otherwise. If the investigation revealed that there was the loss was not caused through carelessness, negligence or error, then there would be a reinstatement.
Yeah, but we haven't got to that point yet, because I'm talking about the situation where you know from the auditor that there is a loss, and now you're deciding whether to suspend or not.
Okay.
And my understanding is this all happens very quickly, more on the same day usually. So there hasn't been an investigation, there's simply been an audit. So in your mind, if you can try and think back and be as objective as possible, to repeat, were you thinking to yourself, well, the post office has got to prove that he was careless, negligent or error? Or were you thinking it's for him to establish that in any subsequent investigation? Establish that he had, I'm sorry,
Yes.
in any investigation.
Yes. Well, when the auditor would phone through with the information that a loss had been discovered, then that loss would be taken as the true situation of accounts, and a suspension would could follow at that stage.
Right.
And thereafter, that's where I described the investigation taking place, and then the sub-postmaster, often with a friend from the Federation, and the contract advisor getting together to establish facts.
Yeah, but so that I understand the nature of that subsequent investigation, you would be provided with what? That's not really helpful to you.
Well,
you first of all get what sort of documentation relating to the loss as found by the auditor?
certainly the audit report would be a key part of the documentation received. And then there may be subsequent inquiries made to establish, for example, were accounting documents relevant in the particular case, training records, and just trying to think any other information that was available from the office records at the time.
Right, but am I correcting in thinking that the first time you get the sub-postmaster's full explanation of why he thinks that a loss has occurred is at the interview that you've described occurring?
At the time of the audit, I would always want to speak to the sub-postmaster to establish whether there was an immediate response to that question.
So are you saying that you would speak to the sub-postmaster if you could on the day of the audit to get an explanation, and then subsequently, he having been suspended, there then will be what I'll call a secondary process in which you're deciding, in effect, whether to lift the suspension or terminate the contract. And at that stage, he'd have another opportunity to describe, to give his version of what he thinks had occurred.
Yes, that's quite right. So the initial questions would be over the phone at the time of the audit, and the secondary investigation you referred to would be after there'd been time to gather together documents, information, and so on.
Right. So at that secondary investigation, let me ask you the same question that I asked you in relation to the day of the audit. At that secondary, or at that meeting, or following that meeting, when you were making a decision, were you saying to yourself, It's for the post office to demonstrate that this postmaster had been careless, negligent, or in error? Or were you saying to yourself, he's got to demonstrate that he hadn't been careless, negligent, or in error?
The second, the sub-postmaster would be required to come up with evidence that he hadn't been careless, negligent, or in error.
Thank you. Yeah, that's very helpful. Thanks very much. Sorry for prolonging your stay in the witness box, but thank you for making your witness statement, and thank you for giving evidence before me today.
Thank you very much, sir.
So, Mr. Stevens, we recommence tomorrow morning at 10 o'clock, yeah?
Yes, sir, for Alison Bolsover.
Yeah, thank you very much.
Thank you.